Hello and welcome to today's webinar, 6-Month Countdown to California Consumer Privacy Act for Retailers. Before our presenters get started today, I'd like to take a moment to go over some CPE and support information with you. To receive CPE for today's webinar, you will need to actively participate throughout the program by responding to at least 75% of the participation pop-ups you will see intermittently throughout today's program. There is a polling question, but there will only be one and it will not count towards CPE credit. For more information on CPE certificates, credit, and support, being technical support or downloading your CPE certificate, you can click on the handout icon at the bottom of your screen for more information, including group participation. If you have a question for our presenters, you can submit those using the Q&A icon, which is also located at the bottom of your screen. Our presenters will review and answer questions found there as time permits. If you have any technical difficulties, you can call the appropriate telephone number located here at the bottom of the screen. If you need to find this phone number later, it is available in the additional CPE and support handout. And now at this time, I'd like to turn the presentation over to our first presenter, Ms. Karen Schuler.
Thanks, Catherine. Thank you, everyone, for joining us today. My name is Karen Schuler, and I'm a partner with BDO, and I run our governance and compliance practice, where we focus on privacy, information governance, national security compliance, cybersecurity, and a number of other things that are related to those areas. With me today is Rebecca Shore from Under Armour. Rebecca is senior counsel and the director of global privacy for Under Armour. She's a global privacy specialist and strategic planner focused on data privacy, policy development, and strategic and operational planning. Most recently concentrating on the evaluation of digital mobile privacy issues and the development and implementation of solutions that meet global requirements. In 2014, Rebecca had established Under Armour's formal privacy program. So Rebecca, welcome, and thank you for taking the time today. We also have Rick Wilson with us today from Sherpa Software. Rick is the Vice President of Strategy and Solutions. Sherpa is a technology company that provides solutions for companies trying to solve their e-discovery, data governance, and privacy challenges. Rick is a certified information management professional, has been instrumental in Sherpa's direction, and has developed solutions that range from email management to policy-driven information governance. So Rick, thanks for joining us as well today. And last but not least is Shannon Yavorsky on the phone with us. Shannon is a partner with Venable and is a U.S., Irish, and English law qualified attorney who counsels multinational clients on a broad range of U.S. and European data privacy and security issues, including the CCPA, which we're talking about today, GDPR, cross-border data transfer, data breaches, global privacy website terms and conditions, data processing agreements, and the EU, US, and Swiss US Privacy Shield requirements. So Shannon, thank you, and to all our presenters, we appreciate you taking the time out. Skipping forward here, let me just get to our agenda. So today we are going to talk about and give you some background on the California Consumer Privacy Act, as well as provide you additional advice and discuss CCPA compliance, how to determine scope and the impact of CCPA, and then really get into what personal information should be considered in scope, how to locate it, and map those sources. We're also going to talk about what is considered selling and sharing data and how to minimize your exposure post-January 2020 while managing risk moving forward. So our goal is really to provide you some useful guidelines that you can use once you return to your office. So let me jump ahead here and get this kicked off. So as you all know, information is really the oil of the 21st century. It's the new gold that runs the digital economy. And data is being mined and monetized to drive revenues and profits, and organizations are amassing and storing more than ever before. Clients use that data in new and innovative ways to deliver artificial intelligence, robotics, and other types of services to their clients or customers. And data can be an asset that can be exploited if it's managed well, but it can also be a liability if you're not managing it properly. It really is the bloodline and the power of a company. But we have to take into consideration, the privacy concerns that the individuals have, especially in the retail space. And in the retail space, more than ever before, do we have to be concerned with what we're doing with data and how we're using it, how we're sharing it, and how we're selling it. Some good examples, of mishandling or leakage or abuse of personal data in the press recently has been, Facebook and the Cambridge Analytica, Google, Target, Equifax, and just by all accounts in that regard, regulatory scrutiny has been very high. Major drivers for implementing really these strong information governance frameworks have been the GDPR, which went into effect last year in May, and now, as we're seeing, California's Consumer Privacy Act, as well as a number of other states that we will mention throughout the presentation today, but just briefly. But what the goal is really for individuals to have enhanced privacy rights in the U.S. when we start to talk about the United States. Bear with me here a second. So these laws, sometimes they pose a burden for the retailers, but at the end of the day, it will enhance really the confidence that you have, the customer has in the retailer, as well as, ensuring that they're thinking about their customers first. When you fail to comply, that's on the flip side. There can be the adverse media attention, there can be the reputational risk, there can be the loss of customers or clients. You might have criminal penalties, there could be civil penalties. Then you also typically have to deal with the cost of data loss and breaches, downtime in the business, possibly lost revenues, and there could be other disciplinary action, including termination for employees. So really this exponential growth of data is driving enhanced privacy and data protection. And we're here to talk a little bit more about that today and how you can help to protect your organization. And as we're seeing, 73% of consumers say they are more concerned today about privacy more than a few years ago. And 66% have changed their privacy settings when they're using an app or some other module. And 67% think the government should do more to protect the privacy of their data. So with those numbers in mind, let's just take a look back real quick. And, as we know, the European Union rolled out GDPR last year. And really it was a little bit around or enhancing what had been the data protection laws of past. And so it's really the regulators that are doing something about consumer concerns. A year later, after GDPR has been in effect and companies are still struggling to figure out what data they have, who has access to it, where it goes, and how it's stored, and ultimately disposed of, that continues to be a challenge, and that's something that Rick will cover today about some ways to locate and map data sources. But companies are better versed, we're seeing, about the regulation themselves. And Shannon will talk a little bit today about some of the things from a legal aspect in terms of what you should be concerned with. And then, even from a data controller perspective and maintaining Article 30 registers, that will bleed into the CCPA and how you can better manage your data. And Rebecca's going to talk more around the operational aspects of what we're dealing with here. So, with this enforcement a year later, you can tell, and we really put this up here for effect. I'm not going to read these, but the violations really, they vary. They've been wide-ranging from not properly disclosing information to users about how data was collected or to provide personalized ads to unauthorized theft of financial information. So this has been widespread. There are small fines. There are large fines. it has been across the board over the last year, and I'm sure we're going to see more to come in the future. So what is the CCPA? So the California Consumer Privacy Act, it's obviously the first one that had been rolled out in its newest form, while we had some others. But now Nevada, New York, Maine, to just mention a few, are rolling out their own laws. The CCPA is really, it goes into effect January 1, 2020, and it really gives Californians comprehensive privacy rights and allows individuals to know what information the company has about them, along with the right to access that information. It gives opt-out functions. It gives the right to equal service, as well as the right to delete their information. So during our webinar today, the presenters will take you into more detail about these categories of information and what the law really means and requirements that will impact each of your organizations. When we look at the comparison between CCPA and GDPR, we really think about, well, how is it different? How is it different from other regulations? So on the screen, you'll notice a comparison between CCPA and GDPR. And while there's some overlap, it's clear that there are differences. And that's one area that we will talk about a little bit today. It's easy to say, well, we have similarities here, but there are real distinct differences. And the demands from California, are a little different than what the GDPR was saying. The GDPR is really about protecting the rights and freedoms of EU data subjects, whereas California has some elements similar to GDPR, but GDPR is really the only one that's principle-based, in its form, and it's set out to protect those rights and freedoms. So not to steal anyone's thunder, I'm going to leave it at that for the time being, and our esteemed folks will get into the details behind that. So before we move on, we're going to have you do a polling question. And the question is, and please answer this, is your company planning to prepare for the January 1st CCPA deadline with internal resources, third parties, or a combination of both? So if you could just click on the appropriate answer, that would be great. All right, so give this a second. It does have a little delay, so bear with us. We just want to give everyone a chance to respond. Okay, I don't think we're completely there, but we're going to move on. So just by way of answers, we do have the majority of you, so 41% of you are saying that you're going to use internal resources and third parties. 36% of you are reporting that you're not preparing at all. And 20% are saying that you will use internal resources, and then 3% of you are saying, only 3% of you are saying that there will be, you'll do this solely through third parties. So let me jump ahead a little bit now as we close this down. It seems like a combination of both continues to jump up in numbers. But moving on, let me get our folks involved here from the panel. And Shannon, starting with you, it's now June. We're about 6 months before CCPA will become enforceable. Given the variety of proposed amendments, lack of certainty around certain provisions, and absence of the AG's regulations, what are the things that companies should hold off on doing, or what should they prioritize?
Thanks, Karen. That's a great question. I think the first thing that organizations should do is check whether the CCPA applies to the business. And the CCPA generally will apply if the business has over $25 million in annual gross revenues, receives or shares personal information of 50,000 or more consumers, households, or devices, or derives more than half of their annual revenues from consumer data sales. But even if your business falls into one of these categories, there are exemptions that may apply. which brings me on to my next point, which is if the CCPA does apply, that you're a for-profit California business and you have ticked one of these boxes, you need to determine what information is caught by the CCPA and determine whether there are any exemptions that apply to the different buckets of information that your organization processes. So I'm going to talk about a few things using our experience from the GDPR that we found really took people a long time and more resources in order to get accomplished. And the first is data mapping, which is inventorying the personal data the business collects. And I know that Rebecca and Rick are going to talk a little bit more about this later, so I'm not going to go into detail there. The second thing is being able to operationalize individual rights requests. The CCPA grants sweeping new consumer rights over personal information, such as access and deletion upon upon a consumer's request. So your business's ability to respond to these requests is going to depend on being able to locate personal information that may be maintained across a number of systems. Your organization may need to navigate a variety of operational issues, such as verifying the identity of the consumer making the request and assessing whether any exceptions will be available to the business. So, in brief, two things that are going to require a long lead time: data mapping and being able to respond to and execute access and deletion requests. There are a few other things that I want to hit on that are also important steps. So contracts, so inventorying the contracts with service providers that may be at issue. The CCPA requires that you direct your service providers to prohibit them from using, retaining, or disclosing personal information except for the provision of the services. So we're telling people now to start, looking at the contracts that they have in place and making sure that they know the universe of contracts that are going to need to be amended. And I think that GDPR is going to provide, helpful guidance to organizations here because they will have already been familiar with doing data processing agreements for the purposes of Article 28 of the GDPR. We think it's also important to take this opportunity to review your company's data security practices and mitigate liability exposure. So the CCPA boosts liability exposure for businesses by providing a private right of action that's linked to statutory damages for consumers whose personal information is subject to a security breach as a result of the business's failure to provide reasonable security. So even though businesses technically have a 30-day cure period of alleged violations before they face statutory damages, this provision is likely to raise both the frequency and the stakes of data security litigation. So it may be time to revisit the data security measures that your organization has in place, and to look at your data security, your cybersecurity insurance, and ensure that your coverage is adequate in light of the potentially expanded exposure here. I think the final thing that we get a lot of questions about right now are privacy policies. So the CCPA includes a number of obligations with respect to disclosures that organizations have to make. And while we're telling organizations to look at their privacy policies and consider amendments that need to be made, we're telling them to take a wait-and-see approach because there are going to be AG regulations that come out this fall, hopefully, and we don't think that you should post a new policy until much, much later in the year. So the wait-and-see approach is what we're advising on the privacy policy for now.
Right. Well, yeah, that's really helpful information. And we do have a quick question here about, so does the CCPA not affect nonprofit organizations?
That is a wonderful question, and that it's correct to say that the CCPA does not apply to nonprofit organizations, but you need to be mindful if there are any for-profit activities associated with the nonprofit. So it's if you are a nonprofit organization, it's certainly worth drilling down on the CCPA's provisions in relation to the nonprofit exemption.
And then there's one more question that I think is really relevant right here. Is the $25 million annual revenues, total revenues, or revenues specific to sales in California?
Thanks, Karen. That is whoever asked that question, that's a great question, and we don't have guidance on that point at this time. So we're telling, our current advice is to look at the total overall revenues of the business and even outside of California.
Great. Thank you. Good answer. Thank you. Okay, so moving on a little bit here. So what do companies have to think about around the differing scope of the laws?
That's also a really great question, and we have a number of organizations who are struggling with the various data protection and privacy regimes around the world. They recently had to comply with GDPR. Now there's CCPA. In the last couple of weeks, we've had new privacy laws in Maine and Nevada, and there are a host of other states that are considering data privacy legislation as we speak. So in light of this evolving landscape of privacy and data security laws, we tell organizations that are thinking about global privacy compliance programs to look to data privacy, accepted global data privacy principles. And some of these are enshrined in the 7 principles in the GDPR, which are data minimization, lawful, fair, and transparent processing, purpose limitation, accuracy, storage limitation, and integrity and confidentiality. So looking to a privacy principles-based approach for a global privacy compliance program is going to put you in a very good position vis-a-vis global privacy compliance. And I think it's important that the data minimization principle, people often ask what that is. And it's really looking at only ensuring that you're collecting the data that's adequate, relevant, and limited to what is necessary in relation to the purposes for which the data are processed. So data minimization is an important privacy compliance principle.
And is there a place to go or an online source? Because one of our questions is what defines a for-profit California business? Is there a place that somebody can check as to determine whether they're a for-profit California business? Or is there a definition of what a for-profit California business is?
I know that people are looking to tax law in California. The CCPA doesn't provide specificity on this point. It may be that additional guidance is issued that will provide more clarity on that point.
And what about, one question that did come up about the scope is incorporated or just doing business in California. I mean, my non-lawyer hat goes to, well, I believe it's just doing business in California, but maybe you can give us some guidance around that.
So I think you really need to look at it. Again, there is limited guidance on this right now. So I think that, a conservative approach would be for organizations to start evaluating what activities the organization has in California. I think people are taking the view that it's a pretty low bar. The CCPA is going to generally apply if the organization receives their shares does business in California and receives or shares personal information for 50,000 or more consumers. And someone pointed out that even a restaurant based in California that takes, roughly 200 reservations a day is going to possibly fall within the remit of the CCPA. So I think it's a pretty low bar to the CCPA applying. And given the potential for liability under the CCPA, we think a conservative approach is best.
Great. Thank you. Yeah, so just moving on quickly here, considering the extraterritorial applicability of the laws, I mean, you're talking about that now, so does it apply? Does it make sense to silo California data in the way that some companies siloed EU data, or not? Or really not to do that because other states are rapidly adopting other privacy laws?
Yeah, I hear you. And we think that given there is a possibility for organizations to silo the data of Californians, but it's going to be a challenging operational exercise. And it would be just difficult as a public relations matter to say, okay, we're going to offer these rights only to people in California. So I urge companies who are considering siloing data of Californians to think about what message that gives to consumers, and also to consider from a high level the broader context of the fact that other states are considering adopting CCPA or GDPR like legislation that may be coming out over the course of the next year. So organizations may have these obligations with respect to more Americans than just Californians in a very short time horizon. So I definitely urge organizations to consider those factors when they think about siloing data of individuals based solely in California. I'm gonna hand back to Karen and Rebecca, who are gonna talk a little bit more about the scope of personal information.
Yeah, no, thank you. So, Rebecca, so how does the CCPA define personal information?
The definition is broader than we generally see in other privacy laws and requires additional diligence as a result of that expansion. It's not to say that there aren't common threads. We see language that speaks to information that's linked or linkable directly or indirectly. These are very common terms used across various privacy laws across the globe. However, the CCPA does include a long list of categories of information that are in scope, some of which were likely not included when businesses had previously accounted for and tag data elements as personal information. As a result, businesses are required to look beyond what may already be in place and evaluate the data they collect against those categories that are listed and the underlying definitions for each category within the CCPA. This includes things like biometric information, internet and network activity, including browser history, geolocation data, inferences, including those that relate to preferences. And there's one additional note that I want to call out for personal data is that it does give a reference to households, and that there is some distinction there with what we've otherwise seen. What does this mean and what is expected of an organization? If a household-related data is connected and linked to that individual or can be reasonably linked, it's now included as part of that data set that makes up the individual's personal information. It does not mean that companies then need to go do backflips to make those connections, particularly when they aren't otherwise being made within their systems.
That's really interesting. We did get a question, Rebecca, that I think might apply here to that first point you made. How does the point of collection requirements of 1798.100b apply to Internet of Things devices that collect consumer information when the consumer does not interact directly with the device? That's quite a loaded question.
It is, and I think it often goes back to, there's a distinction here between like the notice and notification components as well as the definition components of personal information. A lot of it goes back to what you're looking at the system level and what's then being captured. So even if you have a connected device that you might not be directly linking initially, for linking on the back end, you've now made it potentially in scope and tied to that. And that's partly why with this definition specifically, companies should be looking at all the ways that they collect and how it hits up against both those categories and then the description within each of those categories.
Thank you. That's a great answer. So moving on a little bit, how are companies identifying and mapping third parties that are sharing or selling personal information?
So one of the things that companies are doing is ensuring they have an up-to-date data map that outlines the purpose of the collection and the related use cases. From there, they're identifying the third parties that may be in scope under the broader definition of sell, which I believe we're talking to later. But that broader definition includes transferring and disclosing and making information available. Then they're taking that list and further refining it based on the various exceptions of selling. And for the most part, this looks like they're looking at those third parties that fall under the service provider exception. And if so, what additional steps, like we were just talking about, possibly contract modifications, may need to be taken to ensure that it's documented that they fit within that exception. After all of that's done, there's likely a very skinny down list of third parties that remain in scope under the definition.
And what do you have to do to discuss with your business owners or stakeholders, executives, to ensure that they know how to operate under the new definition?
That's a good question. A lot of it comes down to making sure that the business is actually aware of the CCPA and to review each new proposed collection of personal information and new third parties with the CCPA lens. In addition, outlining the related rights of the CCPA and the penalties. However, one of the most important things to talk to the business about is this isn't merely a compliance obligation. That the CCPA has similar foundations and principles as the GDPR, all of which are built on concepts of consent, transparency, and notice, which are key pillars to obtaining and maintaining trust. Along those lines, one of the things I've championed is a concept that we call the GDPR plus approach, and it's taking those principles of the GDPR and applying them more broadly across the globe, so as new changes come into effect, like here with the CCPA, you're able to more quickly move forward. In this approach with the CCPA, it's a sub-layer of GDPR plus. It's obviously adding a lot of complexity. We wouldn't be having a webinar today if that wasn't the case. But it's set up the protocol and the rigor to ensure that you're reviewing and you're conducting evaluations, that you're mapping your data, that you're tagging data elements, that you're reviewing your third parties. Those business owners will already know what to expect and can make informed decisions. Now, if your company hasn't done this because you haven't had to deal with GDPR, you're just not that far along, it's okay. This is the time to start. Start having those conversations with business owners, raise awareness of CCPA and the related requirements, start the conversation about the rights that we've been talking about, deletion and access, about the broader definition of personal data, determining whether or not your activities constitute selling with your third parties. And this is the time to get buy-in with third-party reviews and ensure that each new third party is identified appropriately and all the data that you receive from them or pass to them is appropriately tagged.
Great. That's a great answer and extremely thorough. And, we had two individuals have actually asked a very similar question, and I think the simplest way to put it is, what about employee personal data, employee personal information? Is that in scope with the CCPA?
So
I don't know if that's
currently, even though the title is consumer, it does currently include employees. I know that there is an amendment right now. I don't know if someone else on the phone has further information, but the last I checked, the amendment has not passed to address this particular piece. As I understand it right now, someone correct me if I'm misstating, they are in scope. I don't know if that amendment passes. It's possible that candidates who aren't employees, their data may still be in scope post that amendment.
Okay. Excellent. And Shannon, did you have anything to add to that?
No, I think that's right. I'm not aware of that amendment having passed yet, but it is afoot and something that people are watching pretty closely. I think it's expected, the thought is it's expected to pass, but watch this space.
Interesting. Okay. Well, good. Well, moving on a little bit, let's get Rick involved here. So, Rick, what are some recommendations that you could give the audience to identify and map personal data throughout an organization?
Yeah, sure, Karen. So Rebecca mentioned the importance of data mapping in her last answer. But from our perspective, at least, before the mapping can begin, you really need to conduct a thorough data inventory, because that kind of becomes the precursor to any effective oversight strategy. So naturally, your data inventory should include business applications and databases that you rely on regularly. But just as important, don't forget unstructured content, things like network file shares. For example, one of the areas we frequently see overlooked is content stored on employee devices. For retailers specifically, maybe you need to ask the question, do you have devices in your various outlets or field offices where associates might be storing report information that they've exported out of an enterprise application like ERP or sales automation? Often that's for some very legitimate use case, but unfortunately, they often forget that they've exported that content. It's lying around in a spreadsheet, and they haven't cleaned it up. So that cleanup after the fact really needs to take place. You can spot that with a data inventory, and it's kind of a first line of defense in terms of limiting risk from both the compliance and a potential data leak area if the device is compromised.
You know, this would have been a great spot to add another polling question, and we can't do it, but what comes to mind for me is how many of our attendees have actually completed and keep their data mapping or data inventories, you know, up to date, and I think that's another key point. But Rick, also, what recommendations do you have for a company that has not yet developed a data classification and retention schedule?
Right. So we've kind of expanded on this data inventory, data mapping process. Where is it, and who has access to it, who's using it? After you have that in place, it's really useful moving forward to apply some kind of classification tagging to the items that are surfaced in that data inventory or data mapping exercise. Now, that classification scheme is really going to be dependent on your business sector and your organizational needs. But I would suggest that as you formulate that classification strategy, don't focus entirely on CCPA, or for that matter, any compliance initiative. Keep the big picture in mind. These classification categories, as you apply them, and usually they're metadata tags that are applied to these different documents and files and elements in your information portfolio, they're a great tool for facilitating that larger data minimization effort that Shannon had mentioned earlier is one of the keystones for sort of enforcement moving forward. And limiting that data sprawl can really help control the scope of your enforcement effort.
That's great. You know, we've actually seen a huge uptick over the last, I would say, 12 months in terms of companies trying to get their data classification and retention schedules in order. And there still does seem to be some dated methodologies out there for retention schedules in particular. You know, there's still a lot of managing of spreadsheets, which in my mind just creates more clutter. You know, so one of the recommendations that we've even added to is going to the online data retention schedule capabilities, utilizing your data loss prevention tools for data classification, or at least having software, you know, or technologies that give you kind of a more robust capability for data classification. But those are great points, Rick. Thank you. So, Rebecca, how can you identify these categories of personal information collected about the specific consumer or customer or guest, and how would you collect those categories of information?
So I'm going to make an assumption that everybody on this call has a privacy policy and that they went through some sort of rigorous process to draft that privacy policy. That has put you at a really good starting point. At that point, you should know the broad categories of data your organization collects and the related business processes because you already should have disclosed them. So that's really the first step in kind of going to that deeper level. It gives you the foundation, and you can drill down from there. Once you have that business process, your data mapping and other identification processes will allow you to capture the universe of data that may be available on an individual. It may require you to scan your network, conduct additional stakeholder interviews, but it will give you that broad sense associated with each process. So if someone comes in and wants to know if you're an e-commerce company, what data you have, this will give you that broader category and then potentially the specifics. So ultimately, the work you've done to date on your policy and the data mapping that you either will do or have done, as well as the inventory that Rick just discussed, should provide you with that picture of what you capture on an individual or what's possible within your systems to pull out for an access request or to address during deletion.
Do you think it's helpful to practice this? You know, try it before you buy it kind of theory. You know, try out your methodologies and see if you can actually respond to a request. What would your view on that be?
No, that's a good question. I mean, I think part of this is, for the most part, people are going to start out with very manual processes, and they're not, unless they're very robust as organizations, not going to have an automated capability, and there is a time-bound requirement for access requests. So, yeah, I do think it's worthwhile to go through and test it. You know, oftentimes, you know, I recommend people already have consent for their own data. So then ask their company, pull the data on me that you have. Here's the categories I'm expecting, and see how quickly they can respond. See if they know where to capture it and where to pull it and how to pull it together in the appropriate format.
And I think that's great advice, because I will second that, because we've seen over the last, year that it is one of the biggest challenges is responding to these access requests. So let me move on here. Excuse me. And Shannon, before I put a question out to you, there's a question from the audience that kind of goes back to your original points. And it's, our company deals in B2B transactions. Is a business also considered a consumer under CCPA?
So that's a great question. And I think that business information, for example, just the name of a company is unlikely to be considered personal information, but the extent to which it's a sole proprietorship and the name of the business includes an individual's name, it would be considered business information. I would also recommend that organizations look within that business information and see if there are contact details of individuals at the organization, which would be drawn in under the definition of personal information, as it would include an individual's name, their email address, potentially their other details in relation to that business contact. So currently, business contact details would be included under the definition of personal information, which I think, as Rebecca mentioned earlier, is a really broad definition.
Great, thank you. So let me move on a little bit and ask you, what does the CCPA require with regard to consumer notices that relate to the collection of personal information?
So this is one of the core requirements of the CCPA, is having additional privacy policy disclosures. And kind of like the GDPR, it's one of the only sort of public-facing ways in which organizations can determine what you're doing for CCPA, so it's really critical. The issue is that this is an area where the California Attorney General has been specifically mandated to address in the regulations that are expected to be released this autumn. So in the meantime, what the CCPA says in relation to disclosures, there are a number of things that the organization has to describe in their online privacy policy or in any California-specific description of consumer privacy rights. So you have to describe the consumer's rights under the CCPA, including the rights to access, delete, opt out of the sale of personal information, the consumer's right to non-discrimination, and include a separate link to a Do Not Sell My Information internet webpage. In addition, there has to be a description of the methods for submitting consumer requests, a list of the categories of personal information that the business has collected about consumers, sold about consumers, and disclosed about consumers for a business purpose in the preceding 12 months. There has to be a list of the categories of sources from which the personal information about consumers was collected in the last 12 months, a list of the categories of third parties with whom the business shared personal information in the last 12 months, and a list of the specific pieces of personal information the business collected about that consumer in the last 12 months. So in short, there are a number of different disclosures that are going to be required in the online privacy policy, and I think that it's important to start, looking at your data mapping exercise to ensure that in updating your privacy policy is not going to be as challenging. If you have an up-to-date data map, you're going to be able to answer these questions and update your privacy policy with some ease. I think that the key thing is this wait-and-see approach. So again, start thinking about it and thinking about the categories of information and all the different disclosures that may be required, but keep in mind that the California Attorney General is going to address these disclosures and the regulations that are expected this fall. So again, like I said before, this one is a bit of a wait and see.
Right. Yeah, and we have a question from the audience about, and I think this is a really good question, is does CCPA include requirements for getting consent for receiving promotional or transactional email marketing similar to Canada's anti-spam legislation?
So that's something that I would take offline. There are no explicit consent requirements, but I think it's something that would need to be drilled to understand exactly what the business was doing there, to understand whether there were any consent obligations. While the CCPA doesn't include explicit features in relation to consent, there are other privacy laws in the U.S. that may require organizations to obtain consent to the processing of certain personal information.
Great, thank you. And so how should the updates that you were talking about, to consumer notices, how should they be rolled out, or further amendments that you should consider, and then even addendums to master agreements?
That's a great point. So I think there are two things to unpack here. The first is privacy notices. So the privacy policy itself, and figuring out how that's going to be, how you're going to update that privacy policy, and how you're going to notify consumers that you've made those changes. I think the second bucket of disclosures here is in relation to service provider contracts. So like I was mentioning earlier, organizations should really be doing an inventory of the contracts that they may have in place with service providers, pursuant to which they're passing personal information to the service provider. And that's a really important distinction there between a service provider and passing the information to a business. Service provider is a really kind of a term of art, and it's sort of like the definition of data processor, if people are familiar with that term from the GDPR. It's an organization that more or less acts like a pipe. They don't do anything with the information that's being passed to them. And the contracts that you have to enter into with service providers for CCPA purposes, you have to direct the service provider and ensure that they're prohibited from using, retaining, or disclosing the personal information only for purposes of providing the services under the agreement. And as to how people are updating those service provider contracts, people are looking at their master services agreements, or the main agreement in place between the parties, to determine how the agreement can be amended. I've seen people start putting together a CCPA addendum in a similar way that people started putting together data processing addendums for the purposes of the GDPR. And another question that I receive a lot from organizations is whether they can use their data processing agreement that they had to do for GDPR and leverage that for CCPA compliance. And I tell organizations to absolutely take a look at those agreements and see whether the CCPA requirements would be addressed. And there are a few key things to think about when you're looking at whether there's daylight between those two things. And the first is, sometimes the data processing agreement will talk about personal data as defined under the GDPR. And as we mentioned earlier, that definition is a little more narrow than the definition of personal information for the purposes of the CCPA. So if you're going to amend just the data processing addendum, you may need to expand the definition of personal data there. We also think it's important, if you're going to adapt the DPA, the data processing agreement, to maybe use those CCPA magic words, that use, retain, or disclose, that are enshrined in the CCPA. So that's something else that I think people should think about. The other thing to think about is whether the limitation of liability and indemnification package if you don't have a data processing agreement that address that, whether those provisions, that liability package in the master services agreement, adequately covers you with respect to potential liability under the CCPA. And it may be a good opportunity to revisit that conversation with your service provider and say, hey, look, we have additional exposure with respect to data breach under the CCPA. We need to talk about the limitation of liability, or we need to talk about you extending an indemnity to us with respect to data breach. So now is a good time to sort of think about those things. I'm going to hand back to Karen, who's going to talk, and we're going to talk a little bit more around issues of data sharing and data sales.
Yeah, no, thank you, Shannon. So yeah, around selling and sharing of data, I mean, you can see on the screen here the definitions that California provides to us. So let me flip-flop a little bit on the order of questions here that we wanted to ask the panelists. But Rebecca, what are companies doing to define what's in scope and out of scope when it comes to selling and sharing data?
So what I've seen business focusing on after they have identified their third parties is understanding what each third party actually does for that organization and evaluate the activity against the related CCPA selling exception. So you have this definition, which is very broad and I think much broader than most people expect to see from a concept of selling. But the CCPA does include a series of exceptions. Typically looking at the business process, like, for example, U.S. e-commerce, and the use of the data, like shipping goods, providing services, providing customer support, and understanding where they fit in. Like I said earlier, I think most people are going to find that many of those, in this example for U.S. e-commerce, are likely within the business the service provider exception. And so they're really taking that effort to map the activity and the action of that individual third party against both this definition as well as the exceptions to see if they really fit within this broad definition.
That's great. Thank you. And then, Shannon, in terms of, how is really the definition of selling and sharing data defined under the CCPA? And what does the CCPA mean when they refer to selling or sharing data for commercial purposes?
Yeah, that's a great question. It's arguably the most important right in the CCPA is the right for individuals to opt out of data sales, and it's something that's been, very, topical and very important. And sale is defined under the CCPA as selling, renting, releasing, disclosing, disseminating, making available, transferring, otherwise communicating orally or in writing or by electronic or other means a consumer's personal information to another business or a third party for monetary or other valuable consideration. And I know that a lot of organizations are saying, well, what is valuable consideration? And it's not defined under the CCPA, but the Act authorizes the Attorney General to provide guidelines in furtherance of the CCPA's purpose. So I know that this is probably the fifth time I've said this, but it's another wait and see for additional guidance from the Attorney General regulations. And I'm not saying it's going to be a silver bullet for everything, these regulations, but I do think that it's important to help contour your CCPA compliance exercise. Obviously, organizations need to start now, but we're hoping that the regulations will provide additional clarity.
Yeah, no, that's a great point as well. And we did have a question, and I've actually been wondering this as well. And I'm curious if there's any guidance on, how some of the mobile apps require personal data or else it won't allow you to use it? Is that a violation? Has there been any guidance yet if that's a violation of the CCPA?
So it's a really great question. The CCPA prohibits businesses from discriminating against consumers who exercise rights under the law, but at the same time allows businesses to offer financial incentives for certain data practices or to treat consumers differently where reasonably related to the value provided to the consumer by the information. So organizations should carefully consider any incentives and how to respond to consumers who block sales of their personal information or exercise other rights.
Okay. All right. Well, let's move on. We've got about 7 minutes left here. So we're going to talk a little bit about minimizing your exposure post-January 1. And let me start with Rick. Rick, in terms of what recommendations would you provide the audience about implementing reasonable technical and organizational measures from a security perspective?
Sure, Karen, and we've kind of laid out this nice little chart that's sort of this cycle inventory, and we've talked a lot on this webinar about data inventory, data mapping exercise. As a company who develops software tools, I'd love to tell you that selecting the right technology to manage your information can guarantee you won't be exposed to any undue risk. And our software, or software in general, can be a great help in identifying and monitoring your problem areas from the inventory mapping standpoint. But I guess I would stress, keep in mind that a complete security effort has to include a risk education for your employees and then a set of associated processes that ensure the software alerts that might be turned up by automated software are being properly triaged and remediated by your team. Rebecca just talked about, and Shannon just talked about some of the ways that, under the broad definition of CCPA, that information could be disseminated, and some of that included orally and through other means. So it's really incumbent on the organizations to make sure their employees understand those kinds of requirements and that they extend beyond just documents that are stored electronically, but there's sort of an employee responsibility as part of this effective implementation strategy.
Yeah, that's a great point. And one of the things we've been hearing more and more about out in industry is patching. You know, what increments of patching, because that really goes to showing that you're on the ball, that you're, you know, testing patches and ensuring that you're updating the software as it requests or requires, but also, you know, taking into account how that might impact your business. So let me scoot forward here a little bit. And so, you know, Rebecca, as we think about privacy by design, you know, being the cornerstone of a global privacy compliance program, you know, can companies take the policies and forms that were developed for GDPR and use them for CCPA? And how do you think they will help to show CCPA compliance?
Yeah, I mean, I think that's a really great question, and you know, many of us spent, you know, months, if not years of our lives preparing for the GDPR, and you want to be able to leverage that processes and documentation for this additional expansion into the CCPA. You heard me talk a little bit about the GDPR plus approach that I champion, and that CCPA can be viewed as a subset. This is a perfect example of that. Under the GDPR, you already likely have created certain practices like assessments and data mapping. You have transparent notices. They were already likely put into place to be that demonstration of compliance. Obviously, there's additions and changes that need to be put in place in order to address some of the California-specific requirements, but you can build off of those best practices and leverage them for your CCPA compliance activities. In addition, if you're complying with the GDPR, you've already outlined ways to comply with deletion and access requests, and you've documented the processes. Now, some of the underlying components of access, because again, we said that definition of personal data is broader, will require some tweaking. You already have that process in place, which is really important. So you've set the foundation, and at this point should merely be refining those existing processes to account for the CCPA. And many organizations are kind of debating whether or not to do this, but I think more and more companies are leaning towards this, that if you're going to refine your access process, you refine it across the board. You don't necessarily distinguish by country. And this would just be another example of California might add 3 more data elements. If you have an access process for the EU, you might just add those data elements generally to what you provide back, so you don't have separate processes.
No, I think that's a great point for our audience. Absolutely. So we do have a question, and Rebecca, I don't know if you can answer this, but let me ask it. How should financial data elements be disclosed to the consumer? Our assumption is these data elements would be for disclosure only because there are federal laws for retention, which would exempt deletion. And that does go into the question we had for Shannon about what is exempt. So I don't know, Rebecca or Shannon, if you want to tag team and try and answer the question we just had.
I'll add a little bit to say that, I don't think anything under the law is intended to make the individual less secure. So while there might be other laws, and I'll let Shannon speak to the specifics of that here for financial data, the component of disclosure and those access requirements, we're not expected to do something that is going to make the consumer less safe. That guidance out of the AG that is expected in the fall, I think, will help provide additional clarity. But I think that as you evaluate what you include and what you don't include is a good kind of gut check. I'll let Shannon speak to the other components of that question.
Yeah, I'll talk a little bit about exemptions, which I think will help with this question also. So the CCPA exempts certain financial and health information, and I think it's important to note it doesn't exempt the financial services or healthcare business generally. All personal information, even exempted information, remains subject to data breach lawsuits under the CCPA, so important to bear that in mind. Financial information if the information is collected, processed, or disclosed pursuant to the GLBA, then it may be exempt from the CCPA. If the information is subject to the FCRA or CalFIPA, which is the California Financial Information Privacy Act, or the California Driver Privacy Protection Act, it would be exempt. So I think it's important to note that, you know, it's information that's subject to these laws in general. For health information, the CCPA doesn't apply to information collected by information under HIPAA or HITECH or medical information governed by the CMIA. So just quickly to reiterate, the CCPA exemptions apply only to the information collected for the purpose of complying with these laws. If the business collects demographic or website visitor information unrelated to its services, then the CCPA might apply to that information.
Yeah, and there's a subset of that that might be financially related that is not otherwise covered under some of the exemptions that you mentioned.
Yeah.
Well, that's great. And so just to wrap up here, let me turn it back to Catherine. I want to thank our presenters today and for the audience for attending. We were able to get through everybody's questions. And so, Catherine, would you like to take the helms and close this out?
Sure. On behalf of all of our presenters, I'd like to thank everyone for attending and participating in today's webinar. There were a lot of good questions today. If you were part of a group that was attending today's webinar, please don't forget to submit your sign-in sheet within the next 24 hours. If you were part of a group, your CPE will take a little bit longer to process. Otherwise, if you participated and answered at least 75% of the participation pop-ups, you will receive your CPE via email within the next 48 hours. I do have a question, how many CPE credits were there? And this was worth 1 CPE credit. And thank you all for attending and for all of your good questions, and we will hope you will join us again, and we hope you have a good rest of your day. Thank you very much.
Thank you.